This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law. Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Schnorman.
Welcome to Lawline. Many victim advocate groups feel that the current system is the only way to hold medical professionals accountable for their mistakes. The industry has been lobbying to place caps on awards to victims of medical malpractice, to limit awards to neurologically impaired infants, and to change the basic components of the tort system as it now exists. Our guests are Fred Quella, a medical malpractice attorney and past president of the New York State Trial Lawyers Association. We also have Ed Amsler, Assistant Secretary Treasurer of Medical Liability Mutual Insurance Company, which insures doctors throughout our state. Hello, Fred. Hello, Ed.
Hi.
Fred, all right, what is medical malpractice? I mean, I go to the doctor and he doesn't cure me. Does that mean I could sue him?
Not if he didn't do anything wrong, absolutely not. Medical malpractice is really very simple. It means that the doctor on a particular occasion with a particular patient went through a red light. Shouldn't go through a red light, and if you go through a red light and you injure someone, you're supposed to pay reasonable compensation. If the doctor doesn't act in an appropriate manner, that is the way that other doctors in the community act, and as a result of that departure from good and accepted practice, he or she injures a patient, then the patient should be compensated just the same as if the doctor ran the red light. It's as simple as that.
Now, Ed, I know you represent doctors. And I know it's been the reported position, and we hear it all the time, that doctors feel that attorneys such as Fred and are making doctors leave the profession and practice differently than if they weren't worried that they'd be sued at every turn. How do you answer that?
I don't think there's any question but that's happening. I think the problem is that they're involved in a dysfunctional system. We had a system where we had a physician and a patient, a relationship of trust and confidence that developed. Unlike what Fred told you, I don't think it's so much a system of a red light. I think it's a system of an injury. People who don't get the result that they anticipate from a physician, who aren't pleased with their medical care for whatever reason, and have sustained an injury, they drive a system of fault, which is puts a wedge in that physician-patient relationship. And the system exacerbates that wedge. And it's a system that doesn't work. It's a system that costs a tremendous amount of money, takes too long a time, and compensates very few people as a result. The friction costs of running this system are astronomical.
Now, let me tell you, if I may, 50 years ago, if our family doctor was supposed to put a bandage on the left leg and he took off the right leg, my mother said, if Dr. Cherkoff says take off the right leg, don't question it, take it off. That's the way it used to be. Now, these doctors are held accountable. But I'd like to say something first as a preface. Doctors are good. We need them. We love them. And even a doctor who does the wrong thing and causes harm doesn't mean he's a bad man. It only means that on that particular time, on that particular occasion, he wasn't doing what he was supposed to do in a proper manner. This system that we have ensures that he does, because he knows that if he doesn't act in a proper manner, if he doesn't act according to good medical standards, he's going to be held accountable for that. What's wrong with that? Why should someone who goes through a red light and knocks someone down be required to pay fair and adequate compensation, while a doctor who can many times do much greater harm than an automobile that makes someone have a fractured rib, why should he be an elitist person and not be required to compensate the injured party? What's wrong with that?
I don't think the issue has anything to do with elitism. I don't think the issue has anything to do with red lights. In fact, if any of my clients run a red light and injure one of your clients, I think they should be compensated. However, it has nothing to do with running red lights. It has to do with the practice of medicine, which is both an art and a science. It has to do with a relationship between physicians and patients, which this system is destroying.
Let me
it has to do with cost. It has to do with cost. It has to do with a system where obstetricians out in Nassau and Suffolk County are paying $140,000 a year to insure themselves in professional
Now, that's
liability.
another situation altogether. Let me just tell you what I think
why
about.
is that another
I'll tell you it's a
situation
situation
altogether?
because when I last looked into medical liabilities assets in 1985, when they were in existence in 10 years, they went from zero in 1975 to $2 billion in assets in 1985. That's more assets than 0.5% of all the corporations in the world.
You know what you
I don't
do,
know what
Fred,
they're.
you have to turn
Wait a
the
minute,
page
let me
and look at the
finish.
liabilities.
I don't know what
Have you looked at
liabilities.
those?
Yeah, liabilities. If you're going to have 100,000 claims and you're going to pay them all tomorrow, maybe you'd have a problem. But you don't pay more than I think 1,500
Fred,
a year.
Ed,
That's nonsense.
1 second. Ed, let's assume, for this example, that a patient goes to the doctor and the doctor negligently treats the patient. And the patient is severely injured because it's no question there was negligence. Make it an obvious. He left something during an operation in the patient, and he should have taken it out. A clamp or something, and then the patient was severely injured. What would you propose to compensate the patient? The patient should be compensated.
I would propose.
What would you propose?
I would propose a system where we have out-of-pocket expenses that patient incurs. For example, loss of income as a result of the injury, medical expenses as a result of the injury, paid as they are incurred by that individual. I would propose that a cap be placed upon conscious pain and suffering. That's the great amorphous area where the Bar Association will roll the dice to achieve funds that far exceed the adequate compensation for that individual.
Tell the jury what you think a jury, the jury is the audience, of course. Tell the jury what you think a quadriplegic, a man, let's say someone like Reeves, who, assuming you were in a malpractice, Christopher Reeves, who a young man in his 20s or 30s is quadriplegic. Tell the audience how much you think the cap should be for his quality of life.
It's
an academic question.
I guess you were.
Let him answer.
Well, the answer is let me tell you, it's $250,000. They are proposing that for ruining a man's life like Reeves, assuming he did it in malpractice, and making him into a quadriplegic, that besides paying his bills, he's entitled for his life to $250,000. Am I incorrect?
Give him an opportunity to respond.
Well, let him tell me if I'm incorrect on the money. Is that the cap?
Oftentimes, rhetoric obfuscates reason and justice, and that's what I think we've just heard. What we're concerned with here is how do we? No one can give Christopher Reed his life back the way it was.
Correct. How much would you compensate
Would you let me
him for?
answer, please?
I just want to know, is it
Kindly.
$250,000?
Kindly, let me answer. What we can do for that man, were he a victim of medical malpractice, was to make his life as comfortable as possible and to compensate him relative to that injury for his economic loss, his future medical expenses, and to take care of him relative to that by annuity payments. We can say that the pain that family suffered is worth $5,000, $50,000, or $50 million. And you, nor I, nor any other human being can put a price on that. But society requires injustice, and to keep this system functioning, that we put a limit on that. Because we can no longer afford the luxury of permitting a system to run dysfunctionally, out of control, so that medical services are affected to the people of this system.
Ed, you haven't answered my question. My question is, what would you propose for the loss of his quality of life, for this thing you call pain and suffering? Tell the audience what number you say the legislature should cap the pain and suffering for someone like Christopher Reeves. Am I correct? You're proposing a $250,000 cap for the quality of this man's life. Isn't that true?
He's not on the witness stand.
I can't get a number out of the guy.
What I am proposing, Fred, is that what we do here is that we cap the award of conscious pain.
At what number, Ed? At what number? At what number? Tell the audience.
Please, give him an opportunity, please, Fred.
The rhetoric is...
So what's the question at the number?
Please.
I am proposing, and the legislature has before it, and has always had before it, and it has been in the Senate, a cap of conscious pain and suffering at $250,000.
Thank you very much.
Now, that does not include payments for all his medical expenses, all his future losses, all his physical needs that he needs, including all his nursing care, all his transportation needs, all his retraining needs, all his physical therapy needs, all of those things which he needs to have taken care of. The area that you're concerned about in terms of conscious pain and suffering, or as you put it, in quotes, quality of life is the area which is capped, not his needs.
What you're saying-
One second, please, Fred. What is achieved by limiting the compensation of somebody so severely injured as Christopher Reese to $250,000?
That's an excellent question. It's excellent because it has a synergistic effect on this whole system that most people don't realize. We can sit down and look and see that the costs of taking care of an injured patient, all right? And I really am reluctant to use Christopher Reese. It doesn't have anything to do with professional
No, but people
liability.
understand
that, but
the extent of the
I think
injury.
we do him a disservice, and we do this issue a disservice when we do that. But let's just talk about someone who's severely injured.
Okay.
We're talking about someone who's severely injured, and we say to them, we can project, economists can project what the future costs of taking care of that individual will be for all their needs. We can also project what the costs of the loss of income, for example, if they've lost their income as a result of it, and we can purchase annuity to pay for that. For example, if it costs $500,000 a year to compensate for the medical expenses, for the future loss of income, we can purchase an
I
annuity for
appreciate
that.
all that you point you made, but what I'm saying is, why do you come up with a figure of $250,000 to limit for somebody who is so severely injured? And what we're really talking about, as Fred pointed out, we're talking about pain and suffering and the loss of enjoyment of the rest of the person's life.
What will that cap be at? Let me pose that question to you. Where should we place a limit on that?
You
I don't-
shouldn't. You
Now,
shouldn't
if you
put a
have no
cap at
limit on
all.
it, then the system will fall of its own weight.
Isn't that what it has?
Life
Why-
is filled with limits.
Let me
A
ask you
rational
this.
system
Ed,
requires limits.
if I may ask another question. I know a number of years ago there was a medical crisis. Now,
Let me interrupt. There was never a medical crisis. There was a purported medical crisis that was put on by the lobbyists for the insurance industry, and more particularly for medical liability mutual insurance company. That was the crisis that they created, which never existed.
and today, from what I understand, there are substantially less medical malpractice cases commenced. And in fact, when jury verdicts, I just was reading a jury verdict reporter, doctors are winning their cases more today than ever. Is that
No, I don't know where the idea, and I've heard this before.
From jury
that
verdict
they're-
reports.
Yeah, no, that they're, well, our percentage of cases that we close on behalf of physicians is, without payment, is about 60%.
Wow,
That's good, but it doesn't address a very real issue, which is that at 60% of those cases that cost a tremendous amount of money that have to be defended. So we have 60% of the cases that have no merit to them whatsoever.
No, I
that have to
disagree
be
with that.
closed.
All it means that a particular jury found that the burden that the plaintiff had to overcome was not overcome. It didn't mean that the doctor was innocent. It meant that the plaintiff didn't meet his burden. And one of the reasons we can't meet it is because the doctors are a close-knit group, and the plaintiffs, the injured plaintiffs, can't get the doctors to come in whom they need as expert witnesses to testify that another doctor malpracticed them. And that's why you've got those verdicts in favor of the defendants, not because they didn't maim and
Fred,
mangle the injured victim.
Fred,
And by the way, let
the
me say
logic
this.
fails,
Let me
Fred.
say this to you. I don't mean to cast an aspersion on the profession. I say to you that, like they say, the doctors are my best friends. I love them. But where a particular doctor crosses the line in a particular case, he or she should pay just as any other tortfeasor. You say the system's going to fail? Why hasn't it failed in products liability? Why hasn't it failed in automobile cases? Why hasn't it failed in construction accident cases? Why should there be a privileged group dealing with doctors alone? Why is that? And they're the ones, and when you talk about obstetricians, neurosurgeons, they're the ones, if they cause damage, they cause irreparable damage. You're talking about a child that had a brain that's like cereal. That's just
Ed,
not right.
your response?
Yeah, I'd like to if I can. There are obviously many bills from Washington and in New York State on products issue, but talk to me about an analogy that I think really is somewhat more appropriate. And we're all people, we're all human beings, we all need medical care in our lives. And we have a system in this country, good or bad, of workers' compensation. And workers' compensation was derived just because of that, because we couldn't be productive as a nation and have employees suing physicians without certain limits, without certain programs for compensation for those people. We have physicians and patients in this country, and I will tell you that in the future, if we're going to have universal, accessible medical care in this nation, we are going to have controls on this tort system.
Are you talking about basically, is it your proposal to compare the workers' compensation system to the medical liability
No,
system?
not in terms of compensation. My argument is that Fred makes the argument that we have products liability. We can't segregate that out. I say we do segregate out workers, for example, right now. And I think we need to segregate out professional liability from our tort system.
Ed, we have to go to a break now, but I'd like you to think of the following question. I, as a patient, and that's what I am I entitled to know how many lawsuits were commenced against a doctor that I want to go to? Am I allowed to go get the records to see if there's 5 judgments against him, if there's 10 pending lawsuits? We have to take a break now. We'll be right back. You're watching Lawline. I'm Alan Schnorman, your host. Stay with us. Hello, I'm Alan Schnorman, the host of Lawline, and I want to give you some important information about your legal rights. If you were seriously injured in an automobile, a fall down, or construction accident, you may be entitled to a substantial money award for your pain and suffering. It is important to speak to a knowledgeable attorney in that field. At my firm, Solomon & Schnorman, our practice is limited to personal injury law. We fight for the rights of accident victims. Don't try to evaluate the case yourself. If you have any questions about your accident, call us at 1-800-LAWLINE. If you're too injured to come to our office, we will come to you. The consultation is free, and we only get paid when your case is settled or won. Remember, the insurance companies have lawyers protecting their interests, and so should you. Hello, you're watching Lawline. I'm Alan Schnorman, your host. Today we're talking about medical malpractice. Our guests are Fred Queller, past president of the New York State Trial Lawyers Association, and Ed Amsler, assistant secretary treasurer of the Medical Liability Mutual Insurance Company, which insures your doctor. Okay. Ed, before the break, I had asked you if, as a patient, am I entitled to find out all the information about a doctor that I think I'm going to go to? Can I find out if he's been sued, if there are claims against him, if there are possibly hearings against him by maybe a medical board or fellow doctors in the hospital? Can I get that info?
Can you get it? I think that some of the knowledge, some of the information is public knowledge. I mean, when we file a lawsuit, and Fred may comment on that, but I mean, when you file a lawsuit, the papers are filed, they're there, they're present, they're extant, and you can see that. I don't know that whether there's any New York State, and I'm sure that there is not a central filing area for these things. I'm not sure what good the knowledge would do you.
Well, let me ask you this. Let's assume a doctor was out in Oklahoma and had numerous verdicts against him for medical malpractice. In fact, the hospital that the doctor was with asked him to leave, said, no, we don't no longer give you privileges. Mm-hmm. And then he comes over here, opens a practice in Manhattan, gets something with a hospital here. Mm-hmm. Am I entitled to is there a place I can go to, a central bureau, to find out all these complaints?
I tell you what exists now. Right now in this country, there's a National Practitioners Data Bank. That is a national agency which collects this information, and it is required. We're required to report to them on behalf of our insureds when we make payments and settlements. And when there is any action taken regarding a hospital staff privilege, it goes into that national data bank. It is in turn accessed by all who grant privileges and all who grant licenses throughout this country.
I'm a customer. I'm a patient. Can I get into it?
My understanding is you can't.
No.
That's the anomaly. They're keeping it a secret. First of all, if you take a look at how many times they've penalized doctors for doing wrong, you'll find that it is infinitesimal. They don't monitor the doctors themselves properly. When they finally put it into this national data bank that Ed talks about, then the one who should get it is you and I as patients, and they don't give us access to it. Go figure that one out.
Fred, I think I possibly have a medical malpractice case. Now, I call you up, but first, tell me, what cases do you take? And what cases will you tell me to go elsewhere?
Well, I'll tell you, most cases I'm going to discourage you not to take anywhere, merely because a result doesn't come out the way you like it doesn't mean anything was done wrong. So I listen very, very carefully to see whether it's just that because you wanted your nose to be a little straighter and it wasn't straight, therefore you want to sue the doctor, that in and of itself has nothing to do with it. So I will discourage you most of the time that you don't have a claim until you forget about it. You can't have a doctor guarantee a good result. On the other hand, we'll also won't take cases where let's say on a dental malpractice even, where you can fix it for $3,000, $4,000. You cannot afford to handle a medical malpractice case unless it is a very significant injury. And the reason for that is you've got to pay for expert opinions to come in.
What is significant? Everybody wants to know. What are you talking about? How much?
Is this a system? I mean, what are we talking about here? Is this a system that we're comfortable with as a society? Is this a system where the gatekeeper to it is a determination as to the value of the lawsuit? I submit this to you now, that what drives malpractice in this state, in this country, is not negligence. It is the severity of the injury. The more damaged there is to a patient, the more likely the lawsuit. Now tell me how that correlates to whether the doctor was negligent. Tell me how obstetricians in this state pay such a high premium, are sued so much more frequently, and the damage is leveled against them by these neurologically impaired infants, which are tragic, tragic cases. Why are their premiums so high, their risks so high? Is it because they're all negligent doctors?
No, it's because, I'll tell you why, it's because MLMIC is charging them too much money. And let me finish that point. 10 years ago, when they were in business for 10 years, MLMIC went from zero in assets to $2 billion. I would like you to tell me... Wait a minute, let me finish the point. I had trouble getting the $250,000 number from you, and I'd like to get another number from you. I'd like you to tell the audience how much assets MLMIC has acquired today, 20 years in business, when 10 years ago it was $2 billion. What is the assets of your insurance company that you charge the premiums?
Our assets right now are about $3 billion, in excess of $3 billion. But the more important question is the liabilities, Fred. The problems that you have. You know, you say that it's an insurance industry problem, and that's trying to create a victims out of people. I wonder, where are the commercial carriers in this market if this is so lucrative?
You've got a monopoly on it, that's why.
Do you understand that these physicians, the 14,000 physicians that are insured in New York State through Medical Liability Mutual, are insured through this company and formed a mutual in 1975 because no commercial insurance carrier would write them? Do you think that commercial insurance carriers don't come into the state of New York because they can't? Because they make so much money they don't want to come in.
You have acquired, MLMIC has acquired in 20 years $3 billion in assets.
How many liabilities have we acquired?
But look at the assets that's gone up, and I'll tell you something else. You have never, to my knowledge, paid out one nickel from premium dollar to an injured party. The only monies that you've paid out, from my understanding, for claimants and for your legal expenses is from the earned premiums you've made on these doctors that you've overcharged. The ones who are victims in this case are victims of malpractice, and they're also the doctors. In my judgment, the doctors are the victims of the insurance company who's ripping them off. There's no justification for you to pay that kind.
The problem, the difficulty, Fred, that you don't understand is that the doctors are the insurance company. The doctors own the insurance company,
Fred's making
and the doctors run the insurance company.
Listen to me. When I was president of the trial lawyers 10 years ago, when I met with the doctors, MLMIC tells them, they come once a month to the meeting, these directors, these doctors, and MLMIC tells them, we've got an actuary, and our actuary says you have to pay $125,000 premium. They know as much about premiums as I do, so they say, fine, $125,000.
I have to agree with the last comment you made.
The fact of the matter is, you have acquired $3 billion in assets in 20 years. Tell me, what corporation do you know in the world that comes near it? Less than half of 1% in the world have acquired that kind of assets, and you're ripping off the doctors with these premiums.
I assume 10 years ago, please. Yeah. I assume 10 years ago, when you set your projections for the next 10 years, what you said was we're going to have X number of claims within the coming 10 years, in 1985 or 1986, and we expect to pay out in those 10 years X number of dollars. The question I have is, well, Fred is making a lot of statements that you're basically overcharging doctors. How are your projections, and how is it the actuality?
Let me give you just a couple of differences with the scenario. What Fred hasn't said is that we don't set the rates. The superintendent of insurance in the state of New York sets our premiums. He takes a look at all the experience of all the carriers and sets the premiums. He sets it, we don't. Right? That's the first thing that you must understand. He's charged with representing the interests of the people of the state of New York on that issue.
And getting
Number
back-
two, when we set the premium, not only do the physicians who make rate requests to the superintendent of insurance, who provide filings for that, they say in 10 years from now we'll have to pay this amount out in payments. But we know we're going to earn money on that during that 10-year period. So let's take the amount of money we're going to earn on that and reduce the amount of premium we have to charge. It's called discounting. We discount the premium so that it equals the amount that has
Tell
to
me
be
what
paid
happened.
out.
But you
Please,
never answered your question,
What
Alan.
happened in the
Alan, you
last-
never answered your
Please,
question.
Fred, what happened in the last 10 years? All I'm asking is, in other words, how you made projections. Did you
Let me give you
did you
one.
make money or lose
Sure.
money?
Let me give you one. It depends.
You're not going to
you
get
have
an
to look-
answer.
Please, Fred.
You have to look at every year, all right? Year 1975, the year we started.
I'm not
collected
talking
about
about-
60. I'm just
over the
giving you
10
one year.
over the
picking one
10-year
year.
period.
But some years we lost money. Some years look like they're going to come out ahead. That's where it stands. I mean, it
You've
depends on
never
which
lost
one it
money.
is.
You haven't.
That's
let me
wholly
ask you this question.
inaccurate.
Let me ask
That
you
is
this question.
wholly
Have you
inaccurate.
ever paid out 1 cent of premium dollars to claims? My understanding is that every dime you've paid out to claimants and to defend these cases has been from the earnings you've
did I
made.
just-
Excuse me, on the earnings you've made from the premiums. You haven't paid out any of the money from the premiums to claimants.
You apparently you don't understand the principle of discounting. What did I just say?
I understand you made $3 billion. You have $3 billion
Let me get to a
in
different
20 years.
A
I
different
understand
subject.
that.
Ed, please. A claim comes in, and you evaluate the claim, and you say, oh, my God, this is obviously a terrible case, and this doctor really created malpractice. I mean, I'm looking at it, and there's no question in my mind. Do you then try to settle the case
Absolutely.
right away?
Absolutely. Not only do we try to settle a case, but we sit down and there is our basic philosophy. The company has a basic claims philosophy, which is simply this, that cases of merit should be settled as quickly as possible. There is no case, and I have been in this business for many, many years, there is no case that gets better with time, and I think that's something that Fred and I will agree on, as from a defendant's point of view. No case gets better with time.
Settle it as soon as you can.
Settle it. When you've got a case of liability, settle as soon as you can.
Fred,
There's only one problem. In the 20 years that MLMIC has been in business, and they represent 95% of the doctors, and I've been dealing with them for 20 years, never on one occasion has my office ever received a call from anyone from MLMIC saying, you've got a good case, and we did wrong, and we're sorry, and we want to pay it. Not one call in 20 years. Tell me about this policy you have about
What I was
settling
waiting
cases.
for, Fred, was you to call up and say, geez, we think we made a mistake and we'd like to discontinue this case.
We do that all
So
the
we were
time.
waiting for
Excuse
it.
me.
Doubt
We do
it.
that
Fred,
all the time.
question,
No, absolutely
question,
not. We
question.
take our loss. We take a case and we believe that it's a case. We investigate it. We spend money. We spend time. We put a year into it, and we see from depositions that it doesn't work out. We cut our loss. We take the client in and we tell him it's not a case we
Fred,
thought it
let me
was,
ask you this.
and we discontinue. Just the opposite of what you
Let's
said.
assume I'm a victim of medical malpractice. And let's assume it's a plastic surgery, and I was left with a terrible scar on my face. How do I know what that's worth? I mean, I come to you and I ask, how much can I get?
That's a terrific question. When we say you needed caps, we have an automatic cap in this state. The jury decides. People like you and I, regular people, they decide what it's worth, and they place a number on it, and then also they passed legislation 10 years ago that the judge also has input.
I want to
Let me
know
tell
what
you,
it's worth.
It's
What
worth
would you advise me? What would you advise me?
What we do is
I have a terrible scar running down my face. Quickly.
we look at other cases and see what has been upheld by the appellate division. That's the key. We have a built-in cap. If
Can
the
I get
jury-
$100,000 for a scar on my face?
Well, the question is the scar on your face or on my face?
And with that, thank you very much, Fred Quella, for appearing on Lawline. And then Amsler, thank you very much for coming from Medical Liability Mutual Insurance Company, the company that insures your doctor. And as always, this is Alan Schnorman. Thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law.